And very good morning. How's everyone? Selamat Hari Raya. Maaf Zahir Batin.
Hari Raya, Doktor.
Well,
Ya, Doktor.
okay, it's good to hear from you again. Hope you're coping strongly with COVID and the rest of your life. All right. So basically, today is a session to continue where we stopped last time. There are some more maxims that we have to cover under the topics of equitable maxims. So today, hopefully, we'll be able to finish all those maxims. Just to keep everyone, just to refresh, right? Basically, maxims are just guidance and not binding upon the judges to follow. So maxims are basically maxims are created by the judges. So there are some important points that you have to bear in mind when we use maxim in a particular dispute or in a particular case law. Number one is maxim is not binding until it is applied to the parties of a dispute. Number two, you gonna see or you have already seen maybe in the notes that we have about 14 maxims altogether. Those 14 maxims may overlap with each other. Okay, and if you are looking in a case law, the application of maxim in a case law, the judges are free to use more than one maxim depending on the suitability of the maxim. So if there are more than one maxim to be applied to a particular dispute, the judge can use more than one maxim depending on whether the maxim is suitable or not with the present case. So again, which maxim will apply depending on the facts of the case, right? There are some maxims I mentioned to you just now overlap with each other. For instance, you will see letter maxim number 5 and 6, where there are clash of titles, where there are clash of equitable titles, right? Who will have a better right over? So that one we will discuss later under maxim number 5 and number 6. And we have done before, there are two related maxims. For instance, equity. Who seek equity must come in clean hands. And the other maxim is who seek equity must do equity. There are slight difference between those two maxims because for the first maxim, equity, he who seek equity must come in clean hands. They must not be guilty of any past criminal conduct. But for the second maxim, he who comes to equity must do equity. You do not need to prove that the person has any past guilty conduct. Basically, it's criminal conduct related to the transaction. Right. I will continue with the next maxim. We have actually done this before, but I will just to refresh you on this maxim. Maxim number 4, equity acts in personam. Sorry. So in equity, basically, this maxim is applicable for the enforcement of court judgment, where the court judgment can be enforced against the person, even though the property is located outside the court jurisdiction. This is very much different from the law, because the court, to determine whether a court can have jurisdiction over a certain matter, the court will look at where is the location of the property. But in equity, as long as the person here could be a company, because in company law, company also has a legal personality in law. When I say legal personality, means the person can sue and can be sued in law. So even more for a person or an individual, there can be taken an action if their location based in or within the particular jurisdiction of a court. So let's look at the cases to illustrate on the maxim. In the case of DC builders and REITs, in this case, basically it involved the work done by the creditor. The company, the DC builders, had carried out construction work for Mr. Rees, which is the debtor. So why the construction company, DC builders, is called as creditor? Because Mr. Rees did not pay the full amount of the construction work done by the builder. So they were seeking, the company, the DC builders was seeking for or was demanding for the outstanding balance of the construction work. So when they had a conversation or communication on 31st August 1964, the creditor, the company, the plaintiff demanded £480 for the outstanding balance, but they received no reply from the defendant. The defendant's wife replied to the company, DC Builders, to the creditor that the husband can only pay £300 to settle the remaining balance. So that's only they can pay, that's only they can get, that's only the company can get. At that particular point of time, the creditor had no choice but to accept the offer or the bargain made by the wife, because they were also in a problematic financial situation. If they did not accept the amount, then they would go bankrupt. So they accepted the amount and gave the plaintiff 1 year to settle the remaining balance, which is £180. But the wife of the debtor insisted that never pay the remaining balance. That's 300, that's the only they have. The defendant replied that actually the defendant's wife and the plaintiff replied that they had no choice but to accept the offer from the defendant. So later in the same year, on November 1964, the plaintiff claimed that, because there was actually an appeal in this case, the plaintiff claimed, defendant claimed that the plaintiff claimed that the defendant claimed that the plaintiff did the bad workmanship. So the plaintiff took an action against the defendant to claim for the balance. But the defendant said that since they had done the bad workmanship, so the company, the builder, was not entitled to get the balance of the construction work. So the issue in this case was whether the settlement is binding on the creditor. Okay, basically, if you follow this case from the beginning, the outstanding amount was £480. Okay, but the defendant could not afford to pay the full amount, so they offer to settle the debt by offering £300. The plaintiff did not have any choice but to accept, otherwise they would go bankrupt. So the issue in this case, whether when they had the settlement when the plaintiff had the settlement to accept £300, would the remaining £180 can be written off? Meaning that if the settlement binding, so meaning that the defendant did not to pay the remaining balance. The court held in this case that the original agreement between the parties, which is to pay £480, still valid. The payment of the lesser amount of £300 was actually just to satisfy the debt, but does not relinquish the obligation of the defendant to pay the remaining balance. All right, next case is Ewing and Ewing. If you have any questions, you can just write down your questions in the conversation or meeting chat section. And the next case is the case of Ewing and Ewing. In this case, the settler was born and domiciled in Scotland. So there were about £400 property left by the deceased, by the settler in England, and there was some other about £20,000 property left in Scotland, right? So that's basically the property left by the settler, by the deceased. The issue in this case was raised because the executor, the administrator, the trustee of the estate, as well as the personality. Personality refers to the money and investment. Basically, it's a movable asset. Realty, things like land or immovable asset. So only the deceased were domiciled in Scotland, but the rest of the property or the majority of the property were located in England. The executors were also based in England. So the question in this case, can the courts of chancery in England have the jurisdiction to enforce the trust which is based in Scotland? So based on the maxim of equity as impersonal, basically is to give convenience to the parties. So in this case, the court held that even though there are some properties located outside the English court jurisdiction, the court still can have jurisdiction to hear the case for the convenience of the parties. Because if you understand correctly, the maxim of equity as in personam, the court will enforce the action based on or against the person rather than the property. Moreover, in this case, the property, if you look at the fact the properties were located in England. So the court can assert, the court in England can exercise jurisdiction over the matter. Next case is the case of Penn and Baltimore. Actually, the case that we discussed just now on DC builders should not be there. I think it is somewhere else in the other maxims. I will come back to that case later. All right. The next case is Penn and Baltimore. In this case, there was a dispute between the parties. The land was located in the US, Maryland. The dispute was brought to an English court. So based on the maxim that equity can be enforced against the person, the English court had a competent jurisdiction in this case to hear the case because the parties were all Englishmen or English people. They live in England, they were English, so it's much more convenient for the English court to hear the case. So that's equity because they're based the enforcement of the order against the person rather than the property. Another case that we have come across before as well in the case of Chalaram and Chalaram. So even though the beneficiaries, the trust, the shares, some trustees were located outside England, but in this case the court decided that for the convenience of the parties, since the trustee, even though some of them were not located or were not based in England, they can still come to England at their own convenience. So based on that fact, the court held that the court can have jurisdiction over the matter. Right. That's the general rule basically in the maxim of equity as in personam, where the court can enforce the order against the person. But there is always a exception to the general rule. So for this, there is a section for this. It's actually under Mareva order. So Mareva order is basically an order can be enforced against the property. So let's take, for example, in the case of money laundering, that is a very clear example of Mareva order. Even though the person is a Malaysian, but the court can enforce the order to freeze the asset. Mareva order is actually a freezing asset order, where the court can order for freezing of asset of the defendant. For instance, if the defendant had an account, a bank account in other countries like Switzerland or in other countries. So under that situation, the court can rely on the exception to the maxim. We have a special session on that under topic of remedy later. All right, any questions so far? Is everything good?
Yes, so far
Right.
alhamdulillah.
Next maxim number 5 and maxim number 6. It's actually referring to the competition of titles. So here we are talking about the competition or the clash of two equitable titles or two equitable owners. As we have discussed before, just to refresh you that equitable owner is when the person has equitable right over the land by doing something. For instance, they have oral agreement with the landowner, and maybe they have paid some amount of land price, or they could have paid the full price of the land, or what else? They have paid full amount of price of the land, or they can rely, for instance, on estoppel, where the landowner has promised to the tenant that after some time the land will be given to the land will be given to the tenant. So in that case, it's just that because the land has not been registered, so they become the equitable owner. But in equity, the court still can value the conduct of the parties. So the conduct of the parties can relate to the conduct of the equitable owner. Right. For maxim number 5, when there are two equities, they are equal basically because both had no registered right. We know that in land law, registration is everything, right? So if you register the land, then you have a better title over the other. For instance, you have two equitable owners, A and B. Even though B came to the transaction later, but B came to the transaction later, but B registered the land first, and B would have a better right over A. Okay. So basically, that's the maxim. When there are two equities, they both are equal, but the law shall prevail, meaning that who get the title registered first, then they have a better priority rights over the matter. For this, we need to refer to section 206(1) and 206(3). This is the authoritative reference because we have the National Land Code as the guiding document for any land transaction. If you look at subsection or clause 1 here, if someone has registered the title or has effected the transfer of any title by way of registration, then the person or the owner would have indefeasible legal title, meaning that the legal owner can exclude any caveat or any challenge on the land, right? However, if there are contract between the parties, then the contract will be binding, meaning that you need to follow the terms and conditions in the contract. For instance, there is agreement between A and the owner that after a certain period, the land will be registered. Okay, but the owner, without the knowledge of A, sells the land to B, which is, you can say B is a bona fide purchaser. In that case, not necessarily bona fide purchaser will get the right, even though B is a bona fide purchaser without notice. But because there is a contract already between A and the owner, so the contract will prevail over the bona fide purchaser without notice. Can you understand that? So basically, the basic principle is, if you register your title, you have indefeasible title, indefeasible legal title. That's the basic principle. But if there is a contract, the contract will override, the contract will prevail over clause 1. Meaning that you have to follow the terms and conditions of the contract. So if there is any, if the land is disposed or transferred to a third party later without the knowledge of A can still rely on the contract with the owner, with the land owner, and the contract will prevail over any future or subsequent transaction of the land. Okay. What about if we have both are bona fide purchasers? A and B are both bona fide purchasers. They are buying the land from a fraudulent vendor. So in equity, neither A or B could have a better right. Both are equal. So if any one of them get the land registered first, get the title registered first, then they will have a better right over the other. So the same principle applies here. In the case of Langan and Lee Cheng Kiat, in this case, there was a marriage settlement, but the trust was never registered. When say the trust was never registered, there was no conveyance of title or transfer of title from the owner, from the settlor to the beneficiary. So because the trust was never registered, the title of the land remained in the name of the owner. So when the owner died, when the settlor died, the administrator, the trustee, sold and conveyed or transferred the land to the defendant. So the defendant became the legal owner because he got the title deeds. So in this case, the court held that, okay, if you look at the facts of the case here, there was a trust, but the trust was still put under the name of the owner, meaning that the beneficiary become equitable beneficiary. They have not become a legal beneficiary yet because there was no conveyance or transfer of title yet. However, when the owner died, the trustee had transferred the land or transferred the title to the defendant. So in this case, the court held that defendant had a better title, had a better right over the trust. So if you register the title first, then you have a better right over the other. That's the principle. Any questions on maxim number 5? Is everything okay?
Yes. Okay.
Yes.
All right, next.
Yes.
When there are two equities, again, the same thing, like maxim number 5. But the difference of this maxim with the previous maxim is that when there are two equities, they both are equal, the first in time prevail. What's the difference of this maxim with the previous maxim? In this case, both equitable owners, both equitable titles, they did not, the parties, both parties do not go for registration of title, for instance, or they do not put any, or did not enter any caveat on it. So if they do not register, if they register, of course, the other, any one of them will have a better title over the other, right? If they enter caveat, then any one of them will have a better title because there is already encumbrance, so there should not be any challenge on the land because there is encumbrance and subsequent transaction would be prohibited. So here we assume that there are no restriction, there are no caveat on the land. So in this situation, who come first, we have a priority over the other. So the first equitable owner who had a transaction with the legal owner, we have a better right over the subsequent owner. For instance, A had a transaction with the owner X, and B came later as a bona fide purchaser. It does not really matter, but who had the transaction first with the owner? So we go by time is of essence here. If there was no registration of the land, if there was no caveat entered on the land. Right. In English law, if there are two conflicts of two equities, doctrine of notice will determine. However, this only apply in England. So if you are bona fide purchaser without notice, then you may have a better right over the other. But if someone else has registered the estate, then obviously the person who has the legal title or who has the title registered at the land office will have a better right. In Malaysia, just hold on. Oh, sorry, yang tu mesin lain, sorry. So basically, who has the better title here is who is the first in time prevail. So if you register the land, if you are bona fide purchaser without notice, you may have a better right, but not necessarily so. As you have seen in the case of Bunsun Bunyanit, right? Bona fide purchaser without notice in this case was denied as to their right over the land. You may discuss that case as well as an illustration to discuss or to relate to this maxim. In the case of Valipuram and Palnia Pacheti, in this case, the plaintiff deposited issue document of title as security for loan with B. So the plaintiff later entered into SPA, sale and purchase agreement, but he fraudulently told the purchaser C that he had lost the IDT. The court held that in this case, B remained B got the priority. B got the first right because he still hold the IDT. In this case, even though there was element of fraud, but the court held that it was not the fault of B to commit fraud against C by saying that he had lost the IDT. Actually, he still had the IDT, but he fraudulently told C. In this case, the court blamed C. The court held that the B still had the right, and the court blamed C because that was C's fault not to check on the land register whether there was any caveat on the land. So that's why C lost this case and B retained his possession over the land because he still hold the IDT. So meaning, in other words, that the legal title, since B still hold the legal title, B still hold the IDT, B still hold the legal title over the land, even though there was a fraud. So court blames C here, even though we can actually criticize this case because there was a fraud. But that was the standing of the court lah, basically, by having the IDT, B remain the legal title, the legal owner of the land. Next case is Harun and Nikmah. In this case, the first owner was Harun. Harun had paid full purchase price, but he did not register the land. Later, there was a second equitable purchaser, which was Nikmah. Right, line is not quite good here. Okay. Nikmah was a second equitable purchaser. So Nikmah had paid a substantial amount of the land, took a de facto possession of the land, but she did not know about Harun's contract. So Nikmah applied for specific performance in this case to enforce the sale of the land. Harun knew about Nikmah's action and entered a caveat. So Harun was the first equitable purchaser. Nikmah was the second one. Nikmah took an action to enforce the contract by way of applying for specific performance. Harun knew about Nikmah's action and entered a caveat. In this case, the court held that Nikmah had a better right over Harun because she had been there in de facto possession of the land. And since Harun did not enter caveat before Nikmah buy the land, so he was guilty of gross negligence. Again, the court blamed the first equitable purchaser because Harun's failure to secure the land by way of caveat. The fact that Nikmah had been in de facto possession of the land made she had a better right over the land than Harun. And the other fact that the court also look here is there was a delay, intentional delay in equity. There is a maxim equity would not, delay will defeat equity. Under doctrine of latches that we come to that later. When there is intentional delay, that would defeat or that would diminish the right of the equitable owner to get the land because of the intentional delay. Here, the court see the delay or the postponement of the register of title has denied or has defeated the right of Harun over the land. All right, this is the maxim that I'm talking to you just now. Maxim number 7, delay defeats equity. So if there was an intentional delay on the part of equitable owner, that is considered as unconscionable conduct. So if the delay was caused by the intentionally by the equitable owner, then the court could not entertain the delay as an excuse. So this is basically under doctrine of latches, where the party can be denied, the equitable party can be denied of his or her right to get the equitable relief. In Malaysia, the delay here, for the delay, we have basically the statutory limitation. The time limitation is provided under the Limitation Act. So if for some transaction, there are limits to it. If it is over a certain period, under the Limitation Act, then the party could not seek for the remedy. But if it is not provided under the statute, then you can rely on doctrine of latches. What is the delay if it is not provided in the statute would be determined based on the court discretion. Whether the delay is reasonable or unreasonable, of course, is based on the question of fact, which is based on the unconscionable or conscionable conduct of the parties. So if there is any limitation, any express limitation in the statute, we need to follow the statute. If there is no express limitation of time, under the statute, you can rely on the doctrine of latches. In the next two cases, this case, Smith and Clay, and another case, Alcott and Skinner, both are old cases. Basically, the delay was 20 years in this case, where for the court, the court viewed that the 20 years delay was not acceptable at all, because what Lord Camden said, the delay of 20 years, like where the party has slept upon his right for a great length of time. When you say has slept upon his right, that the party did not really bother anymore about the did not bother anymore about the lateness or about the delay. So in this case, the court said the delay was actually showing that the act was not conscionable and not diligent. So that had denied, because of the delay, that had denied the right of the the plaintiff to claim. Next case, the delay in this case was 6 years. In this case, the plaintiff was a member of sisterhood. She claimed that she had been unduly influenced to bequeath considerable property to the sisterhood. So the claim for undue influence was accepted. However, the period, she left the sisterhood, but the period of 6-year gap, so she joined the sisterhood, but she was unduly influenced, so she left the sisterhood and she come back again to claim her right, but it was too late for the court because between 1879 to 1885 there was a 6-year gap. So 6-year gap was considered as not acceptable as well in this case by the court. Right. But of course, 6 years could be an issue as well, depending on the facts of the case. For instance, if there was an issue of fraud that could only be detected like after 6 years, that could be a different court conclusion as well. So you have to bear in mind that the decision of the court about the delay of time is a question of fact. Not necessarily 6 years is not acceptable, but in that case, that was not acceptable. But it could also be an argument that is still acceptable if the fraud, for instance, was only detected after 6 years, or if the forgery of document was only founded, was only discovered after several years.